Welcome to the Power of Offense with Keith and Rodney, and I'm your host, Keith, and right below me on your screen is Rodney.
Greetings.
Here at the Power of Offense, we entertain you with legal commentary from a layman's point of view. Now, today's show, we're discussing fair use in relation to copyrights. Now, as you can see on your screen, we have a comment from one of our listeners that left a comment in the comment section of one of our videos. And this individual's name is Bachata Intimate. And Bachata Intimate said, "Did you get permission for Kevin Samuels to show his clip? From lawyer to business owner, fair use is not always as it seems. Otherwise, everybody could start a YouTube radio station based on fair use." Now, before we unpack this question, we would first like to thank Bachata Intimate and say that we appreciate your comment. Now, we appreciate it because our assumption is that you want to keep honest people honest, meaning you want to make sure that we are following the law. And we appreciate that. And we actually agree with your sentiment. Now, let's read it again. Bachata Intimate said, "Did you get permission from Kevin Samuels to show his clip?" Now, we're going to answer that later in the show, okay? And then he says, "From lawyer to business owner." So we're assuming that Bachata Intimate is a lawyer. That's the assumption, y'all. All right. Now, what is a lawyer? We have a definition for you because we want to set the stage to everything that we're saying in this broadcast. Now, a lawyer is a person who practices or studies law, an attorney or a counselor. All right. So just from the context clue within the sentence, it's implied that Bachata could possibly be an attorney. All right. A lawyer, a lot of times lawyer attorneys, people use them interchangeably. All right. Now let's go back to the comment. He said that fair use is not always as it seems. Otherwise, everybody could start a YouTube radio station based on fair use. Well, we're going to unpack this, y'all, in the show. We're going to take a look at fair use. And we want to try to discover why is Bachata Intimate saying this, because we can assure you that the videos that we put out, the videos that we publish for you all, right, that our videos are protected under the fair use doctrine. All right. Now, let's look up a definition for fair use. So right here in Google, we have a definition for fair use. And matter of fact, let me zoom in a little bit. Make this a little larger. All right, definition for fair use. It says in U.S. copyright law, the doctrine that brief excerpts of copyright material may, under certain circumstances, be quoted verbatim for purposes such as criticism, news reporting, teaching, and research without the need for permission from or payment to the copyright holder. All right. Again, it says in U.S. copyright law, fair use is the doctrine that brief excerpts of copyright material may. So in this case, we're talking about a video that we published where we were discussing the lawsuit that Jessica, aka Miss Average at Best, filed against the popular YouTuber and image consultant Kevin Samuels, right? So that's the material that he's referring to that may have been copywritten, right? Now it says under certain circumstances can be quoted verbatim, meaning that we played his video verbatim, right? For purposes such as criticism, news reporting, teaching, and research. Now I can assure you that this definition is missing comment, the word comment, okay? And then it says without the need for permission from or payment to the copyright holder. All right. So let's take a look at something, y'all. We have a slogan, and we say this slogan at the beginning of all of our shows. And we also have a notice that's within every single video that we publish. Now, this slogan, right, is a statement. And this statement is that here at the Power of Offense, we entertain you with legal commentary from a layman's point of view. All right. Now, again, I can assure you that fair use right? That it protects commentary, right? And we're going to check that out in a moment. So here at the Power of Offense, right, we entertain you with legal commentary from a layman's. Now, let me define layman for you. Here we go, layman. Now, we're looking at the second, right here, the second definition. And it says a layman is a person without professional or specialized knowledge in a particular subject, all right? That's what we are. So we are individuals, right, without professional or specialized knowledge in law. That's what we're saying, okay? Now let's go back to our slogan. Here we go. So again, here at the Power of Offense, we entertain you with legal commentary from a layman's point of view. So we're giving everyone our point of view, right? By applying law to whatever situation that we're discussing. That's what we do here. All right. So we're setting the stage to explain to Bachata Intimate, right, how we know that we did not, or how we know that we are protected under the fair use doctrine. Okay. Now, let's move on. Now, the reason why this is important, right, is because we understand that ignorance of the law is no excuse. All right. Ignorance of the law is no excuse. Not for me and not for you. Now, right here on your screen, right, we have ignorance of the law is no excuse. And we're going to take a look at this Wikipedia publication. All right. Let's take a look at this. All right. Now, this is basically saying ignorance of the law is no excuse. Now, this is Latin at the top, right? This is Latin, y'all. I'm not sure how to pronounce that. Okay. So we're going to skip.
Non-excuse.
Thank you, Rodney. Which basically means ignorance of the law excuses not, right? And then we have a footnote. It says number 1. That comes from Black's Law Dictionary, 5th edition, page 672.
It's also a maxim.
Say that again, Rodney.
It's also a maxim of law.
Right. Yes, it is. And then it says ignorance of the law excuses no one. Footnote 2.
Yeah.
Yep. Yeah, from Black's Law. Yep, 5th edition. Page 673. That's for those who have a 5th edition Black's Law Dictionary that want to check that out. All right. Now, it goes on and it says that both of these, right, respectively, are legal principles holding that a person who is unaware of a law may not escape liability for violating the law merely by being unaware of its content. It says in European law countries with a tradition of Roman law may also use an expression from Aristotle translated into Latin. You want to read that for us, Rodney?
Nemo Center Ignora legem.
Which is nobody is thought to be ignorant of the law. Or
ignorantia loris nocit.
Not knowing the law is harmful. Y'all hear that? Now that's important.
That's probably the best one right there.
Yeah.
The law is harmful.
It's extremely harmful. You know? Now, like Rodney said, these are legal maxims. Now, what is a legal maxim? All right. I have a definition for that. See, we got to set the stage for this for everyone. Because we're going somewhere with this. Let me zoom this in. All right, here we go. Maxim. It says a broad statement of principle, the truth and reasonableness of which are self-evident. A rule of equity, the system of justice that complements the common law. It says maxims were originally quoted in Latin, as you can see, and Rodney read those for us beautifully. And many of the Latin phrases continue to be familiar to lawyers in the early 2000s. So the fact that maxims, right, are familiar to lawyers, that means that Bachata Intimate should be very familiar with ignorance of the law is no excuse, right? And we're assuming this. And we're assuming it's based upon this definition. Now it says the maxims were not written down in an organized code or enacted by legislatures, but they have been handed down through generations of judges. As a result, the wording of a maxim may vary from case to case. For example, it is a general rule that equity does not aid a party at fault. This maxim has been variously expressed, and we're just going to read the first one where it says, no one is entitled to aid of a court of equity when that aid has become necessary through his or her own fault. Now, to me, right, when I hear that maxim, that equity does not aid a party at fault, that also translates to me that ignorance of the law is no excuse, right? Because if you're not ignorant to the law, then chances are, right, you will make great decisions and you won't be liable within whatever the situation is. Do you kind of get what I'm saying, Rodney?
Yeah.
Trying to make sure I explain that right.
Yeah. And that, yeah, pretty much. But you pretty much summed it up. Like, ignorance of the law is no excuse. So this maxim is pretty much saying that don't try to sue someone. And it goes back to one of the other videos when we talked about contributory negligence.
Yes.
But here you're like contributing. You can't contribute to someone else's negligence where you suffered an injury and you're at fault. Equity will not relieve you. That's what it's saying. So it really covers both.
I agree. I definitely agree. Now, I want to go back to this Wikipedia. I'm calling it a publication, but I don't think that's the proper word to call it. Should I say this Wikipedia definition? Maybe I should say that.
Yeah.
You know, and again, you know, let me also say this, that we know that Wikipedia is not an official source, meaning it's not an accredited source that you can use in an educational institution. We know this. However, Wikipedia does have awesome write-ups and it does explain information very well. Plus, the individuals who input information, in most cases, they also leave footnotes so that you can see, right? You can see where they citing their work from.
References at the bottom.
Yeah,
so that's why I like Wikipedia, because although you can't use Wikipedia, you can get Wikipedia is more of an overview. You can go down to the references and really quote if you're doing any type of briefs or any type of college research. You can read it on Wikipedia, go to the research, go to the references at the bottom, and then quote the references. So this is, to me, is like a great overview of what you're trying to accomplish, but make sure you go to the references, one, to verify, and two, to make this make what you're reading in Wikipedia, what's the word I'm looking for, admissible. You know, right. It could be admissible in college, it could be admissible because my wife teaches college and she says that no one can use Wikipedia. But then when I explained to her that they can go down and do the references, she said that works because they're not using Wikipedia then. You see what I'm saying? So they're using the references from Wikipedia. Wikipedia kind of like gathers, it does homework for you. You just have to make sure you verify it and use the references that they provide.
Exactly. Yep. Now, I wanted to read just this first paragraph on the explanation. And it says the rationale of the doctrine, right? And again, we're talking about the doctrine of ignorance of the law is no excuse. Is that if ignorance were an excuse, a person charged with criminal offenses or subject of a civil lawsuit, right, would merely claim that one was unaware of the law in question to avoid liability, even if that person really does know what the law in question is. Thus, the law imputes knowledge of all laws to all persons within the jurisdiction, no matter how transiently. Even though it would be impossible even for someone with substantial legal training to be aware of every law in operation in every aspect of a state's activities, this is the price paid to ensure that willful blindness cannot become the basis of exculpation. All right. Then it says, thus, it is well settled that persons engaged in any undertaking outside what is common for a normal person will make themselves aware of the laws necessary to engage in that undertaking. If they do not, they cannot complain if they incur liability. Now, I agree with that. To me, that makes sense. And again, that's what keep honest people honest. I agree with it. And I'm assuming that's what Bachata Intimate was attempting to do with us. That's my assumption now. Now, I want to take this even further, right? And I want us to take a look at a Supreme Court decision, right? Where the Supreme Court explains that ignorance of the law is no excuse. Now, it's a reason why we keep on going over this. It's a reason, and we're going to get to that in a moment, all right? But I also want to read that to you right now. All right, y'all, here go the case. The case is Barlow versus United States, and this case is from the Federal Supreme Court, 1833, all right? Now, the Federal Supreme Court is an authoritative source, meaning it is a primary source. All right, y'all? Now, before I even read this, matter of fact, let me prove it to you all by definition. And this definition is coming out of U.S. Legal. You know, I think we need to read this again, Rodney, because, you know, we understand that repetition is the, the cousin of learning?
Yes.
I believe I'm saying it right.
Yeah, close enough.
Yeah. Here we go, y'all. It says authoritative sources. It says an authoritative source in the legal context is a body of law which takes precedence over others. An authoritative source is known to be reliable because its authority or authenticity is widely recognized. All legal information comes from either primary or secondary sources. Primary sources articulate the law. Primary sources include the following: constitutions, treaties, and other binding international agreements, statutes as enacted, statutes as codified, agency regulations, court decisions, right? We're dealing with court decisions. Decisions by agency adjudicative bodies, executive orders, presidential proclamations, and certain government orders, such as some military orders, including some verbal ones. Now, it goes on and it says court decisions, often referred to as case law, have their own hierarchy of most authoritative to least authoritative. Within the federal system, case law from the United States Supreme Court is the most authoritative source of law on the issue. Next will be case law from the Federal Circuit Court of Appeals, then decisions by federal district courts, and then it says in the state context, the decision of the Supreme Court of a particular state is the most authoritative source of law on a state law issue, followed by state appellate courts and state district circuit courts. Now, please keep in mind that our United States Supreme Court is authoritative over the entire court system in America. The court systems in America all adhere to case law from the federal United States Supreme Court. Am I right, Rodney?
Yeah. So that's even the Supreme Court over a particular state. So a particular state can rule one way and use its case law. You can go and find a Supreme Court case in the Supreme Court, United States Supreme Court, and it'll overrule that case.
Indeed. So here we go, y'all. Barlow versus United States. And this is from 1833. All right. So we're going to read something here. We're not reading the entire case, right? But we are going to read just a small portion of this. All right. Here we go. And I'm going to highlight this for everyone. All right. There it goes. Now, it says it is a common maxim, right? We're talking about legal maxims, y'all.
We just discussed maxims.
Yep. Familiar to all minds that ignorance of the law would not excuse any person. Now, any person means you, me, Rodney, Bachata Intimate, or anyone else. It doesn't say it excludes you if you're just a basic layman or a private citizen. It don't say that, right? So the same way that an attorney or a lawyer is held to the standard of knowing the law, you are too, as a private citizen. It says any person, either civilly or criminally. And it results from the extreme difficulty of ascertaining what is bona fide, the interpretation of the party, and the extreme danger of allowing such excuses to be set up for illegal acts to the detriment of the public. There is scarcely any law which does not admit of some ingenious doubt and there will be perpetual temptations to violations of the law if men were not put upon extreme vigilance to avoid them. Now, this judge, right, that wrote this opinion is saying exactly what you heard in Wikipedia. The judge is just saying it, in my opinion, in a more complicated manner. What you think, Rodney?
Yeah.
This is judge talk, legalese.
Legalese, that's what I was about to say. Legalese, that is best.
But the judge is making it clear that ignorance of the law is no excuse, and everyone, right, all persons must be held to this standard, because this will what's the word I'm looking for? This will diminish the perpetual temptations to violate the law. Because basically, if you weren't held to this standard, then people would just go out here and violate the law just so they can turn around and say, well, I didn't know, and use that as an excuse. So I agree with it. To me, it is right thinking. I agree with it. How about you, Rodney?
I totally agree. I totally agree. Now, and it doesn't matter if you don't agree, because this is what it is.
Exactly. Now, we think this is important. No, go ahead, Rodney. I ain't mean to cut you off.
No, go ahead. I forgot what I was going to say, but go ahead. Yeah, okay. It'll come back.
Yeah, it'll come back. No, I was going to say this is important, and we find this important here at the Power of Offense, because what we have noticed is that most people, most private citizens like us, laymen, right, that's unskilled at law, wait on attorneys and other people, right, who's supposed to be professionals in the field, to tell them everything that they must, or everything they feel that they're supposed to know about the law. But my question to you is, how do you keep your attorney in check? Just like, how do you keep your politicians in check, or your state actors, if you don't know what the law is saying?
Or civics.
Yes. It's important not to be ignorant.
Yeah, and that really is important whenever you're dealing with law, civics, or anything of that nature. And it just brings to light. It reminds me of the 1928 handbook, right? Where it explains this high level of legalese to just private people who join the military. This is like an 18, 19-year-old. They make sure they understand civics and the law in which their government is ran, and is very important. So we have to, where did the disconnect happen? Whereas even people out of high school who go into the military is held to a standard before they can move forward to understand civics and law. But yet now, 90-something years later, we don't understand. Most of us don't understand law. None of us understand civics, and we don't understand why. We understand why, but most don't.
Facts. That's why it's so much confusion out here. A lot of people confused because, again, they're ignorant. They're ignorant of the law. Being ignorant of the law is being ignorant of civics. This is how you know your relation to others, and your relation to government, and their responsibility, duty, and obligations to you.